Welcome back to Court TV Live. I'm Julia Janae along with Judge Ashley Wilcott. Thank you for being with us as we continue our coverage in Georgia. This is the newest trial for Court TV. It's the disguised as suicide murder trial for Susan Embert. And this is the third time she has been there inside of a courtroom facing a jury, being tried allegedly for killing her husband.
William Jake Embert was found shot to death in June of 2014, but the defense claims he killed himself. 5 years after her first conviction in 2019, she was granted a new trial after a juror was found to be a convict and as such was ineligible to serve on that jury. Embert's second trial began last December, but the judge declared a mistrial because the coroner testified antifreeze made him change his ruling from a suicide to a homicide.
Yeah, and wasn't supposed to say that word
right.
in front of the jury. So the defense argued that the use of that word was highly prejudicial and evidence had already been excluded from the trial by the judge. So will the third time be the charm? That coroner is now on the stand in Embert's third trial. Let's get you into the courtroom for that pivotal testimony.
That occurred in 2014, June 28, 2014, involving the death of an individual identified as William Jake Embert. Do you have a recollection of participating in that particular situation?
Yes, sir.
All right. And can you tell the jury how you came about being at the scene?
I've got a call from 911 about the death of an individual, possible gunshot. Once I got a call, then I responded to the scene.
All right. And once you got to the scene, what did you do, just generally?
Generally, what normally I do when I get out my vehicle, when I get to the scene, is go and speak with the EMS, and then sometimes the law enforcement be there with them, and sometimes they be doing some interviewing, and then the EMS would direct me into the scene of the house or wherever I'm going to.
All right. And did you have an occasion to do this at this scene location?
Yes, sir.
Was that 2407 Hibiscus Road in Albany, Georgia?
Yes, sir.
Hibiscus Drive. And that location is in Doherty County.
Correct.
As part of what you do you take steps to make identification of the person that may be deceased?
Yes, I do.
Do you take photographs?
Yes, I do.
And Your Honor, with assistance of counsel.
Can I approach it?
Well, let counsel see.
Oh, sure. Got it.
All right. And would you take a look at what's been marked for identification as State's Exhibit 44? And do you recognize it?
Yes, sir.
And can you tell us what it is?
This is one of the ID pictures that I took a picture of.
All right, so you took that picture, that photo ID identifying the deceased person?
Yes, sir.
And this time, Your Honor, State would tender into the evidence State's Exhibit 44.
No objection, Your Honor.
It's admitted.
Okay. At this time, you know, we published State's Exhibit 44. Now, Coroner Fowler, as a result of this particular investigation, did you make an initial determination about manner of death?
Yes, I did.
And did you initially determine it was a suicide?
Correct.
I'm going to hand you what's been marked for identification of State's Exhibit. What's the number? 28. All right. And would you pass it up, please?
Thank you, Your Honor.
Yes.
And is that a death certificate that you had issued? copy thereof?
Yes, sir.
All right. And at this time, the state would tender State's Exhibit 28.
No objection.
Submitted.
We don't have to. Coroner Fowler, did you subsequently change your determination in this particular instance?
You talking about the initial findings?
Yes, of suicide. Did you change that?
Yes, I did.
First of all, is it within your authority to do so?
Yes, I can.
And within your authority, what were you looking for in order to make a decision about whether you should change a death certificate?
More information come to light. I can change it based on other evidence to come to light.
And other evidence can be used, and you have the authority based upon your investigation to make a change if you deem it appropriate.
Correct.
What is your authority if you have the information that would make it appropriate to change?
I have to have other information that I didn't have initially. Then other information come to light. Then I can go back and change the death certificate if it need to be.
All right. And ultimately, as you understand it, even if you have whatever your determination, is it your understanding as the coroner that ultimately whether a crime is a crime, whether a circumstance is a crime, for instance, murder, that would be ultimately determined by the court?
By the court or the coroner? I don't understand the question.
My question is, no matter what you decide in terms of your administrative duties, ultimately, whether the death was a crime.
Your Honor, I'm going to object. This is not a question. He's telling him what that the court ultimately decides.
I'm going to ask you to just rephrase your question so it's not leading.
All right, I'll rephrase. Mr. Coroner, whether or not a homicide is a crime or not, who makes that determination?
I do. I help make the decision based on what information I have.
And what I'm saying is somebody should be held accountable for that. Who makes that determination?
I ring the court. I mean, the DA office or whoever.
All right. With it, you're saying the judicial system
Right.
makes that determination.
Whether
right.
a person go to jail or something, I'm trying to.
Yes.
Yes. That depends on. That's up to the justice system. My job is to come up with the facts, what I see, and what I'm gonna put on the death certificate.
Right. That's what I'm asking. Is that what you do?
Yes.
And it's up to a jury, to your information, to make these decisions.
Yes.
Now, in making your decision to change your findings, did you get some new information?
Yes, I did.
Well, let me ask you this. Well, did you have an occasion to be present during the initial investigation by police officers?
Yes, I was at the scene. Yes.
You were at the scene.
Correct.
And did you make some observations at the scene when you were there making your investigation?
Yes.
Did you have an occasion to observe the defendant here, Susan Embert, at the scene?
Yes, sir.
You were there and you saw her?
Yes, sir.
All right. And is she present here in the courtroom now?
Yes, she is.
And what was the information that she was presenting in your presence to police officers that related to what had happened?
She was making a statement while the police was interviewing her when I was walking up, saying that we was in the house drinking coffee. He was drinking coffee. She was drinking coffee. And they were sitting at the dining room table, and then her husband went to the back room. Then they heard a gunshot, and she ran back to the back room and saw him that he had shot at himself.
All right. Now, you're saying that was she articulating who?
Well, her and her son was there standing beside each other. She said we was in the dining room.
She's representing that it was her son and the victim.
Correct.
That's what she's representing in your presence.
Yes.
Were present at the time.
Correct.
And you heard her say this.
Yes.
All right. And she's telling the law enforcement these things.
Correct.
And did that figure into your initial determination that it might have been a suicide?
Correct.
And why was that?
Because both of them was in the dining room. He was in the room by himself. That's the only way it could have got shot. If somebody came through the window and shot him. But right that, both of them in the dining room, he in the room by himself and the gun went off. That's the only conclusion I came up with.
Was it a factor, the fact that supposedly the son was there?
My interpretation, he was there.
All right. And so, did you get information to the effect that that was not true?
Later on, yes, I did.
Was that part of the factors that went into your decision to change your finding?
It throws a red flag up, I'll put it that way.
And were there other red flags?
Correct. From the other investigation, yes. Other light came to my light from the private investigator, and other information from law enforcement came up later on, yes. Not at that date, but later on.
All right. Now, what I wanted to ask you is this. Was there any pressure, you're an elected official, was there any pressure put on you by, number one, the district attorney's office?
No, sir.
Was there any pressure put on you by the Dougherty County Police Department?
No, sir.
Was there any pressure put on you by any private investigator to make a change in your decision?
No, sir.
Was there any pressure by any other individual for you as an elected coroner of Dougherty County to make a change in your decision about your findings?
No, sir.
And Ms. Fowler, I want to just go from this point. Do we have... All right. Well, you did in fact issue a new death certificate indicating that it was a homicide. Is that correct?
That is correct.
All right. And that is what you stand by at this time?
Yes, sir. That's what I stand on.
All right. The witness is with the court.
All right, cross-examination.
Yes, Your Honor.
And there you have it. The county coroner saying his opinion, it was a homicide. Now, what are they going to do on cross-examination? That is where we are going to head next. We're going to pause it right there, and then we will watch that cross-examination by the defense.
And also, we're following this story out on the West Coast. Ashley Buzzard was back in court today in connection with the murder of her 9-year-old daughter, Melody. We have the details about what happened inside of that courtroom when Court TV Live returns.
I'm going to ask you a lot of intensely personal questions.
From the crime scene to the courtroom, this is Victim to Verdict.
Everyone has this heightened sense of anticipation.
What a day here at Court TV.
Fireworks both inside and outside the courthouse.
Let the cameras roll.
We'll get back to court in just a moment. But first, here are a few cases Court TV is tracking for you. In California, Ashley Buzzard returned to the courtroom today for a preliminary hearing. The defense is requesting a permanent gag order on law enforcement and details from the warrant. Those motions will be heard on January 21st. Just last month, she pled not guilty to murdering her 9-year-old daughter, Melody. Prosecutors say, though, that she shot Melody in the head and left her body in a remote area of Utah. They will not seek the death penalty, but they are pursuing life in prison without the possibility of parole.
And we're tracking this one in Ohio. The state's highest court is going to be determining Sidney Powell's fate after an appellate court overturned her murder conviction in the death of her mother. That happened last year. Now, the Supreme Court in Ohio heard arguments over expert testimony and procedure in Powell's murder trial. She was in college when she murdered her mother, Brenda, and in 2020 she was that happened in 2020, and she was convicted in 2023 and sentenced to 15 years to life. She claims she was insane at the time of the crime. The appellate court granted her a new trial, finding that the trial judge made a mistake in not allowing the defense to present a surrebuttal case at trial, and the state is appealing that decision.
And in Massachusetts, a pretrial hearing for the mother accused of killing her 3 young children in 2023 focuses on logistics of getting her to the courthouse. Lindsay Clancy did appear via Zoom today as her attorneys talked about getting her ready for trial. Why? Well, because she is paralyzed from the chest down after she jumped from a window of her home. The defense says she will need 2 female nurses and a stretcher to be transported to court. But the other side states, nope, she's asking for too much. Clancy has been staying at a mental institution since the incident. The judge will give a written order at a later date before the January 27th hearing. Clancy's murder trial is set for July of this year.
We'll keep you updated on all of those cases. For now, let's get back to Georgia. We're listening to testimony in the 3rd trial for an accused wife, Susan Embert. The coroner is someone who's on the stand now. Their testimony the last time led to a mistrial. Let's listen in to how this coroner is handled on cross.
Good afternoon. So let me just get the timeline correct. You arrived at the scene at what time?
I can't remember. I don't have the folder before me. I don't remember what time I arrived.
Do you have any kind of a ballpark idea?
I really don't.
Okay. When you arrive on scene, you treat every shooting scene as a homicide, correct?
Well, I think you should treat every scene, regardless of look natural, whatever you treat it as a homicide, correct?
Right. You treat it as a homicide, and then you rule things out.
Work your way back down, correct?
Work your way back down, okay. So you arrived on the scene, you know it's a shooting. You can just respond verbally
yes.
for the court? Okay. You entered the house.
Correct.
EMTs showed you the body?
Correct.
And you examined the body?
Correct.
You examined the things in the room?
The body.
The body.
And observed the room, correct.
Observed the room. Observed the gun.
Yes.
Observed the wound?
Correct.
Observed the exit wound?
Correct.
Okay. And all this time, we're going from homicide, ruling out homicide, accident, you end up on suicide, correct?
Correct.
Okay. You weren't under any pressure to pick suicide, correct?
Correct.
You don't have to choose one of those 3 things or you get in trouble.
I mean, I can choose, right. I can choose homicide, suicide, or undetermined. Yes.
So you can choose undetermined.
Yes.
You would only pick suicide if that's what the evidence shows.
Correct.
Okay. So, using your training experience, you determined this was a suicide.
Correct.
You released the body.
Correct.
The funeral home person came and picked it up.
Correct.
All right, let's put a pin in that for the moment to bring in criminal defense attorney Silva Megerditchian. Silva, thank you for joining both of us today. And I think the defense went right to the point that I would want to hear about, which is why not choose undetermined? That is one of the three choices that was available to this coroner.
Yes. Judge Ashley, I'm shaking my head so hard that I feel like I'm going to give myself a headache. Oh my gosh. The dramatic pause in the beginning of the defense attorney, the fact that he jumped right in, this is cross-examination 101 perfection. This is the biggest aspect of the case. Remember, the last trial, there was a mistrial because the coroner changed their opinion. So the defense attorney really has to pin this in the right way to let the jury know, look, you can't trust his findings. Everyone makes mistakes. So what do we believe? His first indication, the second indication, or undetermined? Brilliance. Oh, and by the way, hi, Julia, and hi, Judge Ashley. Thank you so much for having me today.
Yes,
the dream team. I love you guys.
Good to see you. Let's talk a little bit more about this coroner, because you're right. Something he slipped up and said during the last trial about antifreeze that had been excluded via motion in limine. That's what got everything tossed, and we're here again today. So today he didn't mess up. We didn't hear any words that we shouldn't have heard, and we got all the way to cross-examination. How much weight, though, do you think a jury gives a coroner when it comes to an investigation of suicide versus homicide where there's a gun involved? Do you think they give more weight to a police investigator who comes, an accident reconstructionist who looks at the crime scene, or to someone who did the autopsy?
Julia, look, I've done so many trials, and whenever we talk to the jurors outside, it's absolutely how that expert comes across or how that professional individual comes across. Their credibility and their knowledge and their expertise is something that jurors feel. Remember, they're in the courtroom. They see. The coroner, it's interesting, he took a little bit of a drink of water during that pregnant pause that the defense attorney took, calming himself down, it looked like. All of that, juries will take into consideration because everybody knows, no matter how good you are at what you do, mistakes happen. Lack of sleep or family drama. There's a bunch of things that can happen that even a coroner who's done, let's say, 1,000 investigations can make a mistake on. And so the defense attorney is really going to try to shake the credibility. So when the jury goes in the back, they're going to say, wait a second, is it possible the coroner could have gotten this wrong? It's just a natural discussion. So let's see how this defense attorney will really destroy this credibility, because I think we'll all feel it.
Yeah, this cross-examination is critical to this case. Silva, stand by. We do have to get to a break. Before we do that, though, we do want to make sure you have these new developments in the Reiner family murders case. A judge today delayed Nick Reiner's arraignment after his high-profile attorney that we all know from the Karen Reed trial, Alan Jackson, he stepped down, asking to be replaced by a public defender today. Jackson did not state why he wanted to leave the case, but said this during a press conference today.
What we've learned, and you can take this to the bank, is that pursuant to the laws of this state, pursuant to the law in California, Nick Reiner is not guilty of murder. Print that. Print that.
And moments after the hearing, Los Angeles District Attorney Nathan Hochman spoke about how prosecutors will help Reiner's new defense.
In our criminal justice system, every defendant is entitled to a lawyer who will zealously represent their interests and do so effectively. So too is Nick Reiner, whether it's Alan Jackson, someone from the public defender's office, or any lawyer. He's entitled to that lawyer, and we'll make sure he gets that lawyer. Second point, in the process of dealing with that lawyer, we will make sure, the DA's office will make sure, that lawyer is provided with full discovery of all the facts that pertain to this particular situation, whether it's interviews, whether it's any type of video, whether it's any type of expert reports. We'll make sure that that lawyer gets the facts necessary to effectively represent their client in a court of law. And third point, we are fully confident that a jury will convict Nick Reiner beyond a reasonable doubt of the brutal murders of his parents, Rob Reiner and Michelle Singer Reiner, and do so unanimously. Thank you very much.
Nick Reiner is accused of killing his parents, Hollywood director Rob Reiner and Michelle Reiner, inside their home last month. Now, 32-year-old Reiner is the third of Rob Reiner's 4 children, and he has been held without bail since his arrest. He did not enter a plea, but he is no longer on suicide watch.
The beloved actor, director, and his wife of 36 years, they were found stabbed to death in an upscale Brentwood neighborhood of Los Angeles. That arraignment for their son is now moved. As we said, the judge delayed it today to February 23rd.
All right, let's take that break now. When we come back, the coroner in the disguised as suicide murder trial resumes his cross-examination. Keep it here on your front row seat to justice.
You'll hear and you'll see there was no finger on the trigger, no finger in the trigger guard. Those 2 fingers, you'll hear, state expects the evidence will show. That was his right hand. State expects the evidence to show Jake was left-handed. State expects the evidence will show that the gunshot that killed Jake was not a contact shot with his right hand, his non-dominant hand. And you'll hear arguments and a presentation of evidence that he somehow still pulled the trigger. Jake was left-handed. Gun was in his right hand. State expects the evidence will show that.
Welcome back to Court TV Live. I'm Judge Ashley Wilcott along with Julia Janae. Thank you for joining us. That was part of the prosecutor's emotional opening statement in the disguised as suicide murder trial of Susan Embert in Georgia. This is the 3rd time around for the defendant. She was initially convicted in the 2014 death of her husband.
That first conviction in 2019 was overturned after one of the jurors was found to be a convict and ineligible to actually be serving on a jury. The judge then declared a mistrial in the second trial that happened last December because there was testimony about antifreeze that should not have come in at trial, and that same witness is on the stand now.
Yes, and we want to get back inside the courtroom because it's cross-examination. Let's see what all the defense does.
Let's talk a little bit about what wasn't done at the scene. You didn't take specialized photos of the inside of the wound, correct?
Correct.
Okay. You didn't shave the head near the wound?
We don't do that. Coroners don't do that.
Oh, you don't do that at all?
Not the coroners group.
Okay. That wouldn't help you observe whether or not there was any kind of charring or anything like that?
The coroners don't do that.
No coroners do that?
No.
They don't investigate muzzle to target or anything like that?
Right, coroners don't do that. I mean, if you're saying the abrasion or whatever, the coroners don't do that. You can determine the entrance and the exit from my experience working at the GBI Medical Crime Lab. I worked there for 17 years. That's what we did, autopsies. Mm-hmm. So with my experience, I was able to determine that. But we don't shave head.
Okay, so you could refer it out for an autopsy, and they would do all that stuff. They would shave the head.
If it's necessary.
They would look at all that.
If it's necessary.
And they could determine information about how the person died from doing that.
If I didn't have the information, yes, we used the GBI medical examiner to help me to determine that. Mm-hmm. But I had those answers.
So you had all the answers you needed?
At that time.
And the conclusion was suicide?
At that time.
Right. There was nothing else that could have been done to help you get a clearer picture at that time?
At that time.
Okay. Permission to approach, Your Honor. Coroner Fowler, do you recognize the document I just handed you?
Yes.
Is that the first death certificate you issued?
That is correct.
Okay. Move this point to admit this document as Defendant's Exhibit 1.
Any objection?
To be clear, is that duplicative of States 44, or is that a...
Sounds like it's the same thing,
but
that's okay.
You want your own copy?
Your Honor, I believe this is the second.
Take that one.
Oh, okay.
No, this is the second, Your Honor.
Second one.
Yeah.
Okay, yes.
What is that?
Your Honor.
No objection to...
No objection, Your Honor.
Okay, it's good.
Permission to publish, Your Honor.
Yes.
Okay, so this is June 28th, 2014, correct?
June 20th, correct.
And the cause of death is a contact gunshot wound of the head, correct?
Correct. That's what I had.
And this would be self-inflicted?
For the information that I had at the time, correct.
Okay, and self-inflicted would mean suicide?
Correct.
Okay. I would like to just direct your attention to States 28. Do you recognize?
Before we go to break, we have an update out of Utah on day one of what is scheduled to be a two-day evidentiary hearing ahead of the Corey Richins murder trial. Richins was in court today as a judge ruled on the defense's motion to exclude testimony from 3 of the state's expert witnesses. The judge ruled one domestic violence expert cannot testify, but that ruling is subject to change later if new evidence is introduced. A handwriting expert will be allowed to testify, and another violence expert may give partial testimony, only in the state's rebuttal argument and only if the defense makes a broad claim about how violent crimes are committed. Take a listen as the judge explains all of this.
In the event that the defense makes an assertion in its defense case that is categorical and general. For example, something to the effect of that it's simply not credible that a person would engage in a weeks-long campaign to kill another person in the absence of an imminent threat to their safety. Then Ms. Amon's testimony regarding the retrospective study of completed killings showing a feature such as a preparation and plan over time would be helpful to the trier of fact under Rule 702A to rebut that generalized categorical assertion by the defense.
Corey Richins, the defendant here, she is accused of killing her husband, Eric, by giving him fentanyl-laced cocktail in 2022. Prosecutors say that Richins wanted to cash in on his life insurance policy. A year after his death, this is what really made her case intriguing. She was a grief author. She published and promoted this book. It was a children's book about grief. Then she was arrested and charged with his murder. And despite new evidence of a drug dealer recently recanting his story, a judge has still denied her bond, and that happened again in November. Her trial is expected to begin with jury selection on February 10th.
All right, time to take that break. We will, of course, have more testimony from the coroner in the disguised as suicide murder trial of Susan Embert when Court TV Live continues.
School shooting that broke hearts around the country and broke trust with law enforcement.
Now, the officer sworn to protect those students faces a jury.
The Uvalde School Massacre Trial. Live coverage today on Court TV. Tonight on Closing Arguments, new developments in the murders of Rob and Michelle Reiner. We'll show you everything you may have missed as we preview what is next.
Closing Arguments with Vinny Politan, tonight at 8, 7 Central, only on Court TV.
Welcome back. Let's head back together to court for more testimony from the coroner in the disguised as suicide murder trial.
Yes.
And this is the second death certificate, correct?
You're right. Gunshot went up the head. Yes, sir.
Okay. And so this would be filed on 8/26/2014, correct?
Correct.
So this is when you changed your finding from suicide to homicide?
Correct.
Okay. Now, starting, I want to say in September, you were contacted many times by Lee Wilson, is that correct?
I don't remember the number of times that he spoke to me a number of times. Correct.
Okay. You were also contacted by Rachel Embert?
Yeah, the family. I don't know their names, but the family, yes.
Lee Wilson wanted a copy of the death certificate, correct?
Correct.
And he contacted you a few months after that, correct?
I don't remember the timeline, but I know we did talk different times.
Okay. And then you had a phone call to schedule a meeting. That phone call was in November 2014, correct?
I don't remember the dates, I'm being honest.
Okay. And at this time, he was trying to encourage you to change the ruling from suicide to homicide. That was the purpose of reaching out.
No, we wanted me to investigate more to determine the issue. Because the family had a lot of questions concerning the death.
Mm-hmm.
So he was investigating it. So then, as I had told him, if you find some other evidence to come to light, you can bring that to me, then I will look more back into it.
Okay. And so at this point, he's still trying to bring you evidence to get you to look back into it.
Correct.
Okay. So the problem I have is this says that you changed it. You're telling this jury you changed the death certificate, you changed your conclusion on 8/26/2014. Is that right?
I can't remember the exact. I say that's on the death certificate.
But you're talking to Lee Wilson and meeting with Lee Wilson months and months after that, and he's trying to get you to change the cause of death.
Well, like I said, I found out all the information after that day. All the information came to light, then that's when I started looking more into the scene because I didn't understand the scene, the layout of the scene.
Do you understand what I'm asking?
Not really.
Okay. Lee Wilson is contacting you way after August 26, 2014.
I don't remember the date he contacted me on it.
Okay, but we've already established it's after 8/26/2014, haven't we?
Okay.
Would there have been any reason
I don't remember the dates per
for
se.
him to contact
They
you?
would ask that the defense allow the witness to answer the question.
Let him finish his answer to your question.
So I'm saying to say I don't have a timeline dates that he came and meet with me, nor the family. I don't remember the dates. I'm just being honest. So the timeline from that date of saying suicide to the August, the 14th, whatever date it was, I found out other information helped me to determine that.
So you found out other information after 8/26/2014?
I found out information before that.
Before that,
Yes.
right. That's my question. Why is Lee Wilson trying to get you to change your ruling if you've already changed it?
He just wanted me to investigate it more.
Okay. This death certificate says gunshot wound to the head, correct?
Correct.
Okay. Shot by another, correct?
Correct.
You are telling this jury that this is when this decision was made. 8/26/2014.
That's the date it was filed, yes.
That's the date it was filed. Why is Lee Wilson contacting you months after to get you to change your ruling if it's already been changed?
Your Honor, I believe that question's been asked and answered.
I do not believe I've received an answer, Your Honor.
I don't know why Lee Wilson contacted me later on. He said the family had concerns about the death.
Okay, hold on one moment.
Getting a little contentious there, a little fiery
yes,
between
very
the
fiery.
attorneys, the objections. Let's bring in our guest, criminal defense attorney Silva Megerditchian, to see what she thinks. You already said you thought this cross was a masterclass, Silva. What about the prosecutor trying to protect their witness as he's really being hammered there?
Yeah, I mean, they have to, Julia. They have to break this up because the defense is cool. His coolness is actually very powerful. I mean, I wrote it down. The problem I have, it's a problem we all have. It was beautifully done. And he's trying to tell the coroner, essentially, the prosecutor wanted you to investigate this until we're able to prove our case. That's what he is trying to set forward, that the only reason why the coroner changed anything about his report, which he had already put in the death certificate, is because the prosecutor was putting heat on him. Again, simplistic, effective, directed. It's a masterclass on how to be simplistic but effective. Beautifully done.
I just want to do a little deeper dive into that to say this. It's also masterful because you are taught to do cross-examination and that the question you ask is what you want the jury to hear. You're not focused on the answer of the witness, it's the question. And he also said one other thing in his question. He was trying to get you to change the cause of death. And so you're listening to this and you kind of lean into the defense's theory of the case. Here's my question for you. If this defendant is the only person who is going to, and I don't know if this is true or not, we haven't heard all of the evidence, but if she's the only one that's going to say the victim had any depressive thoughts, suicidal thoughts, any mental health concerns, is that enough? Or would you expect that we are going to hear from someone that says he had these concerns about his mental health, which makes it reasonable for a person to believe it could have been suicide?
Judge Ashley, utopianly, right? In a utopian world, you want there to be someone outside of, you know, the defendant stating that there were mental health issues or depression or suicidal ideation. You don't want the woman charged with killing to be the only one who's like, but look, he was depressed, he did it to himself. The jury will put so much more legitimacy and water if there is someone else who can attest to it. It needs to come from somebody else to be most effective. But again, if cause of death can be a reasonable doubt situation, that really helps the defense with beyond words. But yeah, mental health, I want a third party outside of my client to testify to the victim's feelings of suicide if there was suicidal ideation. It's imperative.
I completely agree with you, Silva. We'll see how this trial unfolds. Thank you, of course, to Silva Megerditchian for joining us tonight.
And ahead next hour, we are going to continue our coverage of the coroner testimony, the disguise of suicide.